Hello, and welcome to today's webinar. My name is David Ford. I'm the Executive Director of CalHIPSO, and we are pleased to welcome everyone to today's webinar on email, texting, and HIPAA TCPA compliance. We're expecting a very good turnout. I see a lot of attendees still rolling in, and I'm very excited to see that and welcome, and thanks for sharing all of your time today with us. A couple quick housekeeping items before we get started. As you sign on to the webinar, all attendees, as you heard from the little electronic voice, are in listen-only mode, and your lines have been muted. We do hope to have a few moments for Q&A at the end of the webinar, but we ask that everyone use the question box that you should see on the right side of your screen to type in your questions, and we will try to get through those. I know today's presentation is going to be very packed with information, so if we don't get to questions, we may do an FAQ at the end of the webinar. And also, if you have follow-up issues after the webinar, you can use that email address that you see on the screen, info@calhipso.org, to send us one-off questions, and we will try to relay information back as best as we can. So with that, if we can go to the next slide. We get a lot of folks on these webinars who may not be as familiar with CalHIPSO. We are a smaller organization, but we are now 10 years strong in the world of health information technology. And CalHIPSO was founded in 2010 by a confluence of three large provider trade associations: the California Primary Care Association, the California Medical Association, and the California Association of Public Hospitals and Health Systems. We were originally created to be the federally designated regional extension center for the majority of California. And in that program, our role was to help providers really to adopt electronic health records and to achieve meaningful use. And if we can go to the next slide. But now, you know, as I'm sure all the providers on the webinar are aware, the Meaningful Use Program is coming to its end in the next couple of years. And so while we are doing a little bit of work still, meaningful use, what is now known as promoting interoperability under the California Technical Assistance Program, CalHIPSO is also branching out into many other directions. Last spring, we started an effort with a company called Alidate to provide practice transformation support services to accountable care organizations. Just in January, launched the first two accountable care organizations, one in Northern California and one in Southern California. And not public yet, but there are some big news coming in the world of health information exchange as well that we just heard about earlier this week. All total, CalHIPSO has helped just over 13,000 clinicians statewide. Providers working with CalHIPSO have earned just over $300 million in federal incentives through various programs. But all that's in the past. And today, we are very excited to be joined by our colleagues and partners at MyConnect Solutions. And so to kick off the real meat of the webinar, I'd like to pass it over to their CEO, Iki Bordargam, and he'll be introducing the company and today's presenter. Iki, take it away.
Great, thank you so much. Good afternoon and welcome. My name is Iki Bordargam. I'm the CEO and founder of MyConnect Solutions. We offer worry-free IT and cybersecurity solutions to organizations that are in highly regulated industries, such as FQHCs. We're very happy and excited to partner with CalHIPSO to be able to present to all of you topics that impact your day-to-day work. Our presenter today is Paul Hales. He is an attorney licensed to practice before the Supreme Court of the United States and a graduate of Columbia University Law School with an international practice in HIPAA privacy and security. Paul is also the author of All Content in the HIPAA eTool, which is an internet-based complete HIPAA compliance solution with editions for healthcare providers, health plans, business associates, and third-party administrators. If any of you are interested in seeing a demo of the HIPAA e-tool, please don't hesitate to reach out to me after the presentation. With that said, I'll hand it off to Paul.
Thanks very much, Icky and David, and welcome to all. Let's take a look at our agenda for today. We're going to talk about HIPAA and the TCPA. And the TCPA is a federal law, the Telephone Consumer Protection Act. HIPAA, a federal law that you're familiar with, Health Insurance Portability and Accountability Act. And I'm just going to give you a brief overview of those. And then we'll talk about the HIPAA rules for email and text messaging. And we're talking here about regular standard emails and text messages, not encrypted, the kind of emails and text messages that we use every day and that your patients want to use to engage with you. There are encrypted email and text message solutions. They are still a little bit clunky to use, and I'm sure they'll get more user-friendly. They're really helpful within an organization where you can download the app and you communicate using encrypted email and text messaging seamlessly. I'll give you some key definitions, and then we'll go right into the three-step safeguard. And this safeguard will completely protect you as an organization, whether you're a provider or a health plan, a covered entity, from violating HIPAA. And it begins with something called the duty to warn, and you see it in quotation marks on the screen. Those quotation marks are actually in the Federal Register. They were put there by the federal regulators, but this duty to warn is by no means as ominous as it sounds. It's a very light duty, and I'll explain it to you. And then we'll talk about the TCPA, which I will have explained to you earlier in the webinar. And there are myths that are actually very dangerous involving the TCPA when it comes to text messaging with patients for certain types of information, like an appointment reminder or post-discharge instructions. So I'll show you, we'll bust the myths, and we'll show you how to comply calmly and confidently. And then I'm going to explain when you must encrypt, and the HIPAA and CMS have made that very, very clear. And we'll talk about some tips for enterprise-wide compliance. So as Icky said, I'm a lawyer, and I created all the content for the HIPAA e-tool. You're going to see one form, one of many forms that are in the HIPAA e-tool that enables you to follow this three-step safeguard. And I need to just make this brief disclaimer that this is education about the law. It's not legal advice. So HIPAA is law, TCPA is law, but legal advice is something you get from your lawyer, someone with whom your organization has an attorney-client privilege relationship. Now, even among healthcare lawyers, HIPAA is a very, very narrow specialty. So everything that we do has an exact citation to the law. You'll see some of them as we go through. Let's move on. It's important for you to realize that the HIPAA rules are easy to follow step by step when you know the steps. And I say that without hesitation, but I've been doing this for 20 years. And the issue is, of course, that there are just a lot of different topics, but we've broken them down into easy to follow steps. The HIPAA e-tool has a search box. It's like a Wikipedia for HIPAA. And the reason that we put it on the internet was to make it available, accessible, and affordable for nonprofits, for small providers. When the HIPAA privacy rule came into effect, it was just the big insurance companies and the big hospitals that had the resources to follow. But of 700,000 healthcare providers in the United States, more than 90% are either small or nonprofits. So I wanted to put a full, easy to use set of tools on your desktop. And David mentioned meaningful use, and now it's promoting interoperability. And one of the things that basically, if you use certified electronic health record technology properly, you meet the requirements to attest that you're entitled to the financial incentives, except for one, and that is doing the HIPAA risk analysis and then managing the risk that you've identified. In the HIPAA e-tool, we have an interactive, step-by-step risk analysis that builds your risk management and documents it, and it is it's a key feature. So when CMS has been auditing, the folks who've had to pay the money back have invariably not been able to produce documentation of risk analysis and risk management. Now, to HIPAA and TCPA. HIPAA is a 1996 statute. It was amended in 2009 by something called the High-Tech Act. It was originally passed for a number of reasons, but when the HIPAA privacy rule came into effect in 2003, since that time, those letters, HIPAA, have stood for one thing in the minds of the general public and the healthcare profession, and that's health information privacy. The Telephone Consumer Protection Act was passed 5 years earlier. And it was passed at a time when people used telephones, landlines, and they're federal laws, and they both apply to healthcare text messages. And they coexist. They are not contradictory. The TCPA is enforced and implemented by the Federal Communications Commission, and it focuses on telecommunications. HIPAA is administered and enforced by a office in the Department of Health and Human Services, the Office for Civil Rights. In both cases, Congress authorized these departments of the executive branch to create rules, and it's called administrative law. And the HIPAA rules that we talk about are the privacy, security, breach notification, and enforcement rules. The HIPAA and TCPA are really about different subjects, and they have different purposes, and they have different ways of being enforced. The HIPAA privacy rules are focused on health information, and their purpose is to protect individually identifiable health information about you or me that identifies us. And it's enforced by government agencies, and they can assess civil money penalties for violations, and also a criminal violation of HIPAA is enforced by the Department of Justice. The other civil enforcement is through the Department of Health and Human Services and state attorneys general. The TCPA subject is about telecommunications that are sent automatically, not something that you just well, I guess we still say dial a phone, but sent by something called an auto dialer, by landline, fax, to a cell phone, to a landline phone, or by text messaging. And the key is that these are sent by what's called an automatic telephone dialing system, or an auto dialer. And right now, there is a controversy about what an auto dialer really means. Now, in California, you are in part of what is the Ninth U.S. Circuit Court of Appeals. And the Ninth U.S. Circuit Court of Appeals has defined an auto dialer as something that can send automatically telephone messages or text messages from a list. So internet to text messages, for example. Other circuits have said that an auto dialer has to be able to generate numbers itself. So, starting with an area code, a prefix, and then 0000, and then 0001, and so forth. So the circuit courts have split, but when you're in California, your law now is that if you've got a system that uses lists or sends out information like appointment reminders to your patients without human intervention, that's an auto dialer. That may change, and the FCC is in the process of trying to review and come up with a better definition of auto dialer. Takes time. California, consider you're using an auto dialer. And the purpose is to protect consumers from nuisance and invasion of privacy. And, back in '91, it was really focused on not getting sales calls when you were having dinner. And there's a safe harbor. In other words, that's something that completely protects you against any violation of the TCPA, and that's obtaining a consumer's prior express consent. And the enforcement is through the Federal Communications Commission, attorneys general. They can levy civil fines, but the main enforcement, the thing you have to worry about, are private lawsuits. And there are substantial money damages to private patients. HIPAA doesn't create a private right to sue. The California Medical Information Confidentiality of Medical Information Act does create a private right to sue. But even under HIPAA, class action lawyers are using HIPAA as a standard of care, and they're bringing class action suits more and more for breaches, for violations, persuading courts that it's like a medical malpractice suit where the organization failed to meet the standard of care set nationally by HIPAA for protecting health information. If you see something that says our service is HIPAA compliant or TCPA compliant, be wary, because no product is HIPAA or TCPA compliant. It's how you use the product, how you follow the rules. And we'll talk about that today, what the rules are. Now, here's why TCPA is so dangerous. Each text message is a violation, and the cost per violation set by statute is $500. And if the court finds that the violation was willful, it can be tripled to $1,500 per violation. So that's why this is a promised land for class actions, and that's why you see so many of them. And perhaps you don't see them, I see them, but again, that's my job. Here's some examples of settlements, recent settlements. Most of these cases are settled, they don't go to trial, but you can see the large numbers. And breaking news, just on Monday of this week, the Seventh Circuit Court of Appeals affirmed a district court judgment in a TCPA case. This comes out of Ohio. And in that case, it held the owner of this company, as well as the company, personally liable. The owner had purchased this, it was a spinoff from Allscripts, and $5,700,000. And here's the case. And the issue was that the owner hadn't gotten prior express consent. And look, it was 11,418 faxes. That's really not very many when you're pumping these automated messages out. But at $500 a fax, it's close to $6 million. So this is a real danger. And it's important to know, though, that prior express consent, I'm going to talk about that and how HIPAA helps you, is the TCPA safe harbor. And this private right to sue creates significant risks for you and costs. And, you know, the hammer comes down and has come down on federally qualified health centers as well. You're doing great work. You have a wonderful mission, but for a plaintiff's lawyer or an aggrieved plaintiff or group of plaintiffs, if you violate, you're a target. So let's look at these HIPAA rules, and I want to start with these key definitions, and there'll just be three of them. One is electronic transmission, and it's defined in the HIPAA rules, and you see some, you see 45 CFR. That's a reference to the Code of Federal Regulations, and that's where this definition occurs. And it means data that's in electronic form that's transmitted over the internet. It's an older law, so it uses the word dial-up lines. I often wonder if my children would even recognize what dial-up lines really means, but it includes emails and text messages. So those are covered by HIPAA. And the word encryption, also defined by HIPAA. And what it basically means is it's a method of scrambling data that's either transmitted or it's in your smartphone or your laptop or your computer. So there's gibberish unless you have the exact key to decrypt it. And there are specific, and Icky would be very familiar with this, but the specific standards for encryption and decryption. And then I want to talk about the meaning of protected health information, because that's something that's misunderstood by the general public. Protected health information is not just information about a diagnosis or a treatment or a surgical procedure or a prescription. HIPAA defines it as health information that identifies an individual. That's what the law calls us, human beings, patients. Identify, that's key. Identifies a patient and relates to the provision of health care or the person's health condition or payment for the provision of health care. So, and health information is information that you'd gather from a patient when they first come in to be treated. So that raises the question, under HIPAA, what is information that identifies a patient? HIPAA calls them identifiers. And there they are, and there are 18 of them. And any one of these connected to the provision of healthcare is protected health information. I'll single out two for purposes of this webinar: telephone number to which you send a text message, and email address. So an email address and a telephone number from a provider to a patient, from a patient to a provider, that's protected health information right there, the email address and the telephone number related to protected health information. So I asked someone, an IT person who spoke plain language to someone like me, what it's like. What is an unencrypted email and unencrypted text message like? And she said that it's, imagine that you're sitting in a stadium and you see a friend across the field and you want to send them a message. So you write on a piece of paper, fold it in half and hand it to the person next to you and ask that it be sent all the way around to your friend. Well, everybody through whose hands it passes can read that message. It's not a secure way of transmitting information. And it doesn't take a sophisticated hacker to be able to intercept and read these emails and text messages when they're not encrypted. And each email has something called metadata, and that includes information about who's sending it, what the subject is, who's it sent to. You can Google and look for Google email headers, and you'll see all the information and how to find it that's in these emails. And the FCC, in regulating internet to phone text messages, points out that they originate as electronic mail, emails sent to the patient's telephone number and the wireless provider. And they use as an example this group of numbers to Sprint. So these can be intercepted, read, and the criminal, the hacker, is going to know who you are, that you communicate, who your provider is, and so forth. Now, here are examples of two, simple, an email on the left, a text message in the middle. And all they say is, "Hi, Paul, your appointment's on March 4th. Well, is that PHI? Well, the myths that you see on the internet, and there's a cottage industry of internet of HIPAA advisors, says things like, don't put PHI in the email subject line, or don't put it in the email or text, or put only the minimum necessary in. And they'll also say that emails and text message appointments are, quote, HIPAA compliant, unquote, no authorization necessary. That's a myth. And the reason is that right there, the email and the text message has PHI. And it has PHI because it's got the each one has an identifier, and appointment reminders relate to the provision of healthcare. So we know who I am and that I've got healthcare, an appointment. And it's really important because medical identity theft is the fastest growing type of identity theft. I'm going to play you a very short video created by the Department of Health and Human Services that explains this. But the FBI says that medical identity is worth 50 times more on the black market than a single credit card number or social security number, because it's used to commit health insurance fraud and get prescription medication. And they're looking for it. The dark web, it's full, and you don't even know that your medical identity has been stolen until you receive a bill from the insurance company for a procedure you never had. Let's take a look at this.
Many people know the dangers of having your identity stolen, but most people are unaware of the fastest growing form of identity theft. Medical identity theft occurs when someone steals or unlawfully uses your personal information, like your name, social security number, or Medicare number.
Medicare fraud cannot be committed without two pieces of information: the identity of a provider and the identity of a patient.
That's important. Just two things: the identity of a provider and the identity of a patient. And you've seen how and why an email address and a cell phone number are identifiers. And so once they have that, you are at risk. Let's take a look at a very brief snippet from the same video. All these are available on the government
I got a
website.
call one evening. A man told me I was approved for a back brace through Medicare, and I gave him my Medicare number and my debit card number.
So we feel sorry for her, but she's a senior citizen. That doesn't matter. These thieves attack people of all ages and all walks of life, and they use what they call social engineering, and these are clever scripts. They're passed around on the dark web, and they are used to call people, or they're ways of sending phishing emails. There are new terms: vishing, it's voicemail or voice phishing, smishing, short message service, text. They're doing email harvesting and phone number harvesting. They are really on top of it, and it's a huge danger, and you need to be aware of it. And once it happens, and if it happens as a result of you're not following the rules, well, it could result in money damages that could really hamper or impede your mission. Now, these are relatively new rules. The privacy rule came into effect in 2003, but it was amended following those 2009 High-Tech Act. And that was where the duty to warn was first explained on. And there you see the page 5634 in the volume 78 of the Federal Register. And then it was repeated involving the three-step safeguard was repeated for the security rule in 2014, and then in 2016, the OCR issued a lot of guidance. We printed it out and made it in little books, 40 pages long, but it's about an individual's right to have access to their unprotected health information, and they've got the absolute right to receive it through unencrypted emails and text messages, if you use this three-step safeguard. And lest there be any doubt about text messages, in 2018, the senior HIPAA compliance official, Roger Severino, the attorney who is the director of the Office for Civil Rights, at the annual HIMSS conference in Las Vegas, talked about and gave a presentation about text messaging. And he said, they're electronic messages, and you've got to use the three-step safeguard. That wasn't news to those of us who understood what electronic messages meant, but some vendors were saying that Director Severino was legislating from the podium. And that just really shows how much misinformation is out there about the TCPA and this so-called healthcare text message exemption. So the three-step safeguard is really very simple. The first step is to notify, and that's what's called the duty to warn, but it's a very light duty. You have to let the patient know that there's some level of risk that information in an unencrypted email or text, that's just a standard email or text, can be read by someone else. That's it. And then you let the patient decide. And if the patient prefers to receive these unencrypted emails or texts, they have the absolute right to receive them. And the fact is that both for patient engagement purposes and for the convenience of the patients, in our experience, 99% plus say, sure, I want to get my messages, whether text message, appointment reminders or whatever, by unencrypted text. I like to get the emails with the wellness newsletters. I want to get my lab results by email. And then the third step, and remember this is HIPAA, is document. You have to document these things under HIPAA. It can be documented electronically, but document that you've given the warning and document the patient's decision to receive unencrypted emails or text messages. That's it. That's simple. It's 3 steps. It's funny, we can break most HIPAA requirements into 3 steps. I don't know why that's the case, but that's what we found. Here is a form from the HIPAA e-tool, and you can, and it's downloadable to put in your new patient registration forms or your patient information update. It's also part of another form that we have for patient confidential communications, where they want you to communicate with them by alternative means at alternative locations. And you see in the box the light warning, and then the patient can check yes, and they commit to maintaining their email address and their cell phone number current. The patient can also check no. But when you have done this, and you can do it on an iPad, you can do it on a piece of paper, however you do your new patient registration or your patient update form, scan it, put it in the chart, put it in your electronic health record system, and you've got it. You're protected. That's the 3-step safeguard. But of course, a patient could say no. And if a patient says no, well, once again, it's 3 steps. And the first one is obvious. Don't send the unencrypted emails or text messages. But then you have to take action. to prevent sending. And it may involve removing a email address or a cell phone number from an old health record or a practice management system. You make sure you notify everybody involved, either in your staff or if you're using a business associate to send these out, notify them in writing. If you're using a business associate, or if you're a business associate listening in, the contracts that you have inevitably say, and I haven't read one that doesn't, that the provider or the health plan is responsible for obtaining all necessary consents, and if they don't, they're going, and the vendor is sued. The provider plan will indemnify and hold them harmless. So put that back on the vendor. Document in warning that they're restricted from sending emails and text messages to this patient, but also in warning, just in writing, keep a record of what you've done to prevent sending unencrypted emails and unencrypted text messages to people who don't want them. And it's important to know and understand that this three-step safeguard is a complete safe harbor. And you are not responsible if the message goes astray during transmission, and you have no responsibility for maintaining its privacy once it's received. Now, workforce training is important. And your frontline workforce, the folks who deal day in, day out with the patients, are key to HIPAA compliance. And, you know, it's important to train them. And I don't have to tell you this, you already know it, but they're professionals. They consider themselves professionals. They may not have all the degrees and certifications of the senior management and the compliance officials, but they consider themselves to be professionals, and they do an important job. And in fact, these rules are simple. They're easier to follow, the HIPAA rules, than the traffic laws are when the front desk staff drives home, or the customer service representatives of health plans. And it's really all about the quality of your organization, and make it part of the quality of their work, the esprit de corps. And it's important to explain why there's this need to warn. And the reason for that is that this is information that they can use at home. When it alerts them to being aware of email and pop-up ads and text message scams and so forth. So it's the best kind of training. It's not just for work, it's for personal privacy awareness. And don't take a long time. You can train them about this particular topic in 15 or 20 minutes. And I always recommend that you have regular sessions, maybe once a month, hit a topic. It's a lot better than bringing somebody together, a group together once a year and giving them an hour of video or something that they're not going to retain, and it's not relevant to them. What they need to know is the HIPAA rules that apply to the protected health information that they deal with on a day in, day out basis. And here's something that's really important. If you're a compliance official, make sure you've got the form that has the correct step-by-step procedures. I'm going to show you some examples from a major academic institution that I got just last month, where they don't use the right forms. And they give them to the front desk. Front desk doesn't know what they are. They have patients sign on a little tablet. You don't even know what you're signing. Give them the right forms in addition to explaining them. Now, let's go to that 2015 order and the so-called healthcare text message exemption. So it doesn't apply to any calls or texts about bill collection or debt collection, and it doesn't apply to this so-called exemption. And the exemption means you don't need prior express consent for certain types of healthcare messages only under the TCPA. So it doesn't apply to advertising. What it focuses on, and these orders come to being because organizations petition the Federal Communication Commission to change the rules. And in this case, the majority of the petitioners that wanted to have the rules changed so they could do text message billing collections. But the FCC didn't go along with it. They said if you've got a treatment purpose, and there are 8 specific topics, like appointment reminders or preoperative instructions, then you can send a text message without the prior express consent, but only under specific special conditions. And that's where the rub is. And by the way, when I'm talking about these informational messages, this is only under the TCPA. Under that HIPAA 3-step safeguard, you can exchange protected health information with your patients on any topic. You know, it's not a good idea to do that, but you can have safeguards in place. Make sure you're using the right email address and so forth. And remember, they've got the right. If they're maybe they're housebound, or maybe they're away, maybe they want to ask you or talk with you by email or text message. They have the right to do it. So the specific special conditions that are listed in this lengthy order, there is one that's a key special condition. It is the primary special condition. There are things like you can't send more than 3 messages a week. It has to be free to the end user. But what everybody overlooks is the plain language of this condition. Any text message sent by or on behalf of a healthcare provider, these like an appointment reminder, has to comply with the HIPAA privacy rules. It's right there in this paragraph 147, section 3. Has to comply with the HIPAA privacy rules. You have to comply with the HIPAA privacy rules to comply with the TCPA. What are the HIPAA privacy rules? Well, I've just shown you. It's the 3-step safeguard: the warning, the patient's agreement, documentation. So to comply with HIPAA, you got to follow the 3-step safeguard, but it also is necessary to comply with the TCPA, because sending a text message under the TCPA about an appointment reminder, you got to comply with the HIPAA privacy rules. That 3-step safeguard's a complete safeguard for you. That's the language. So when we look at that, what you see is that the 3-step safeguard, the warning and the agreement, the documentation, is documentation of prior express consent in writing. That, since 1991, has been the TCPA safe harbor. That is prior express consent. You don't have to worry about the rest of this stuff, trying to only include 8 different types of informational messages in your text. You get that 3-step safeguard, comply with HIPAA, you're good. That so-called healthcare text message exemption that a lot of vendors cite, and a lot of the so-called experts on the cottage industry of HIPAA compliance advisors that's grown up on the internet, it's worthless. And not only that, it's dangerous, because it promotes non-compliance with HIPAA. If they say all you need is for the patient to give you the cell phone number, and then you can go ahead and just start texting them their appointment reminders and so forth. No, that is not the law. So if you comply with HIPAA, with the 3-step safeguard, you are complying with the TCPA. It is prior express consent. Do it. Don't worry about trying to shoehorn your organization into some kind of healthcare text message exemption. Avoid that slippery slope. It's a myth. The HIPAA rules are a blueprint to avoid TCPA danger. When do you have to encrypt? For emails, originally, they said it's addressable. And text messages, any electronic transmission, but that in itself is misleading, because addressable means that you need to encrypt if it's reasonable and appropriate in the circumstances of your organization. If it's not reasonable and appropriate, then you have to document why it isn't reasonable and appropriate, and then you have to document and use another safeguard that accomplishes the same purpose. So it's not optional. And when a lot of people misunderstood that, but working to do all that documentation is more work than encrypting. But in 2014, HHS came out and flatly said, encryption is reasonable and appropriate to safeguard emails. So you need to encrypt your emails, with the exception of that three-step safeguard. At the same time that they were saying encryption is reasonable and appropriate, they said under the security rule, they said that the privacy rule gives patients the right to receive unencrypted emails and text messages if they've been warned about the risks and they preferred to receive them, and you've documented it. So when must you encrypt text messages? CMS came out with this guidance in late 2017. Here's what it says. Secure texting is permitted, that's encrypted texting, among members of the healthcare team. It's still not permitted for the texting of orders. They're concerned that orders have to be made record of, and you're using electronic health record systems, so this computer order entry is preferred. But secure texting of PHI among members of the healthcare team is mandatory under CMS. So encrypt all emails and text messages containing PHI, except when you're following that three-step safeguard for emailing and texting patients. So in terms of compliance, review your enterprise-wide procedures, revise them, make sure that they do comply with HIPAA, and that they're consistent through the organization. We see large organizations or even medium to small size organizations that have forms that have been around for a while, and they've been modified, but now you've got forms that aren't consistent, and make sure you have the correct forms that are available. And then encrypt the emails containing PHI, except for the patient's right to follow the three-step safeguard, and train your workforce. The correct step-by-step forms are really essential. You've been converting to electronic health record systems, and you're aware of the problems with legacy health record systems, but there are equivalent problems with legacy HIPAA policies, procedures, and forms, but they don't stick out to you the same way that a legacy electronic system does, because the electronic system just doesn't work the way you anticipate it to work. And people assume that these forms that have been around for a long time must have been vetted and reviewed and created by somebody who knew what they were doing. Here's what I found on January 23rd when I went to the doctor. And then this was at a major medical, wonderful, highly respected healthcare provider. And I was asked to sign a form. I was just told by the front desk that it's the, quote, HIPAA form, unquote. Well, I asked to see it in paper, and it was entitled Authorization for Medical Treatment and Financial Responsibility. Here's a couple of things that were in that form. And you can see somebody somewhere in that system had read the TCPA, and so they've got TCPA language in there. By supplying my mobile phone number, email address, I authorize my healthcare system to use a third-party automated outreach messaging system. That's an auto dialer. I understand notifications may be repeated more than 3 times a week. And it also said this, and I'll put a red box about it. You may not believe what you're reading, but this is on their form. I also authorize my healthcare provider to disclose to third parties who may intercept these messages. Who in the world's going to intercept the message? Who are they asking me to authorize them to disclose my information. Well, yeah, hackers and criminals. You know, I'd hate to be the lawyer that has to defend something like this in court, and you don't need to. Avoid this. Avoid the legal bills and the staff time that it takes to deal with forms that aren't correct. A week later, I went back to the same hospital to a different department, and that was January 30th. And I was given a form that is intended to, I suppose, to accomplish the same purpose as the form that you've seen earlier. And it's entitled Authorization to Utilize Unsecure Communication for Appointment Reminders. So I've taken some language out of that, and I've removed the name of the person. But, you know, here it says by giving my mobile phone number, email, address, I authorize a third-party automated outreach and messaging system. They even use the word auto dialer here. They say it can be repeated more than 3 times a week. And they've got that same language in there, asking me to authorize that the healthcare provider can disclose this information about me, identify me and identify my provider to anybody who intercepts it. Truly unbelievable. In the same organization, of course, has a notice of privacy practices. And here is the notice. I downloaded it just earlier this week. The red letters are in the form that you download from their website. And of course, there's a portion where it says how we can use and disclose health information about you without your written consent. And one of those elements, as you're well aware, is activities permitted or required by law. And so it goes on to list the typical activities, things like, reporting for public health purposes and to coroners and in response to judicial subpoenas. But then as you go through this list, it gets to activity number 12, billing and collection. Now, this is in the same section that's required by law, but it's about billing and collection. And it says, we may use or disclose your health information and contact you with any telephone number associated with you, including wireless top numbers. Use an auto dialer for collection, and text message or emails using any email address may be also used in order to contact you. Now, a notice of privacy practices has a purpose. The purpose is to inform a patient how you are going to use or disclose their protected health information and how you're going to protect it and what rights they have with respect to their own protected health information. And when they sign an acknowledgement of receipt, that's all they're doing. They're acknowledging that they've received the notice of privacy practices. It's not an authorization. But again, here somebody went through saw the new Telephone Consumer Protection Act and thought, oh, okay, well, we'll protect this entire huge organization by sticking something in that says we're going to use an auto dialer. That doesn't get it. It's not an authorization under HIPAA. It's not the 3-step safeguard. It's not prior express consent. It's just a big mistake. So if you have these kinds of things, change them. They stick out to me like a sore thumb, but this is what I do. So you also may be in a situation where you have to train laterally or up. So working with your compliance colleagues, sometimes there is dispute, security. The IT department says, well, we're in charge of security, or you have people with different opinions. Senior management is responsible. They've got the legal responsibility. Now they delegate authority to compliance officials to implement and develop. They have a compliance program, but they're the ones that are responsible. And first of all, they often don't know really what's going on. And I'm speaking in very general terms. and they don't realize the level of their legal responsibility, nor do their boards of directors. So if you're the compliance official, you need to train up. And, it calls for using your best diplomacy and build a consensus, get colleagues involved. And before you raise the issue, gather your facts. You'll get a copy of this. This is an example of the urgency. You look at your compliance issues, build a team and a strategy. And your message, both to your colleagues and your senior management, is that health information privacy, since the time of Hippocrates, has been the bedrock of high quality care. Patients have to trust that you'll keep their information confidential and use it for the purposes for which it's given, or they're not going to give it to you and you're not going to be able to treat them. And explain the issues, but also explain that there is an urgent need. I don't think anything makes it more urgent than the possibility of being sued, especially if you're in California, where there is a private right to sue, but under the TCPA and under the creative use of the HIPAA by class action lawyers. So the HIPAA rules really are easy to follow step by step when you know the steps. And what we focus on doing is showing you how to do what you want to do and comply with the HIPAA rules. And if you do that, you can comply calmly and confidently. So we've reviewed these steps, what HIPAA and the TCPA are, and the duty to warn, and when you must encrypt, and the myth of the TCPA healthcare exemption text message. I want to go ahead and let's move on into questions. And we do have a little time to get some questions if you could enter them. And of course, email info@CalHIPSO with questions that we don't get to. And here's our contact information for Icky and for myself. So let me take a look and see what questions we might have.
And Paul, while you're doing that, this is David Ford. I'm going to jump back in just real quick because I meant to address something up front. It is always the number one question, which is, will this presentation be available afterwards? So I'm just going to make this available real quick. This session has been recorded. We both put it on the CalHIPSO webinar channel on YouTube, and then we link it to the CalHIPSO website. So give us a couple days, but probably by Monday or so, you should, if your colleagues who couldn't join us today, will be able to see the presentation on the website.
Terrific, thank you. David, I'm looking at the chat message. I don't really see the Q&A on this board.
Well, Paul, I can give you, we've got time for maybe one or two of these. And I'll just start here with one that just came in. Sure. Did I hear you correctly that texting of orders is not prohibited, even if it is secure?
No, texting of orders is prohibited, even if it is secure. CMS totally prohibits the texting of orders, even if they're in an encrypted text message format. It is a complete prohibition. CMS permits the secure texting of protected health information among members of the healthcare staff. So you encrypt the text messages when you're working back and forth with text messages containing protected health information about patients, but you can't text orders. And their preferred method is CPOE.
Okay, perfect. I think where that might be the only question we're going to be able to get to in the verbal presentation. I see that we're losing attendees as we speak here. So, and I see there might be a few questions we didn't get to. So, like we talked about before the presentation, maybe we'll try to get an FAQ because we are getting some more questions. So we'll try to get up an FAQ, and then and also as we said before, if you're interested, you can send your questions to info@calhipso.org, and we'll try to get those answered as well.
And I would say Icky and
I'm sorry.
I would say also send them to Icky or to me. We'll collaborate with you, David, and we'll just make sure these questions get answered.
No wrong door. We will make sure, however you get them to us, we'll make sure they get answered. With that, we are at the top of the hour. And so I want to thank everyone who attended today and took your lunch hour with us. And a huge thank you to Icky and Paul for putting this presentation together. And I will do my one quick plug. We hope to see everyone in Sacramento on Thursday, May 7th for the annual CalHIPSO conference. Registration is open and early bird registration runs through April 7th. Thank you very much for your time, and the webinar will now be closed.
Thanks very much for your attendance, folks.
Thank you.